Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, America, we have had a great run with the United States Supreme Court this year. As a matter of fact, we isolated 4 cases and we ended up going 4 for 4. It was an absolutely glorious session this year before the United States Supreme Court. Well, that was until today, because today, we got our ass handed to us. And I'm just going to be real honest, this is a very, very disappointing day. Not a totally shocking day, but we really took one on the chin here as it relates to a couple of huge issues that are apparently now a long, long way from being resolved. So today, let's get you all educated and let's talk about a bloodletting at the Supreme Court today. Okay, hey, before we get going too far down the road, we are going down. We tell you here all the time at Washington Gun Law, we're not going to tell you how to think. We're just going to give you all the stuff to think about. Well, does the news treat you the same way? And that's why I've been using Ground News, because in today's world of media bias and censorship, Ground News gives you the freedom to learn for yourself, attach your own weight to the facts, and come to your own conclusion. Wow, what a concept, huh? Here's how it works. Take today's story, for example. You start searching it out, and now, 1, you can see who the news source is and what is their political leaning. 2, you can learn who actually owns those individual news sources. 3, you can see the headline manipulation, so now you understand how the story is being distorted. And most importantly, 4, the biased distribution of each story. But then there's a lot more cool features, like Discover Plus, which is unlocked only with a Vantage plan. But here you can customize your own news feed to cover the topics that interest you the most, like, Second Amendment news. Then Ground News will populate your news feed based upon these settings. Here's the best news. Right now, you can get 40% off a Vantage plan by visiting ground.news/Washington. Listen, it's time that you break free from all the media bias and manipulation. It's time that you start being able to make up your own mind. It's time for the news to start treating you like an adult. For more information, visit my good friends at ground.news/Washington. Okay, America, this is what we're talking about. We are talking about numerous, and I do mean numerous, orders that came out of the United States Supreme Court, kind of their last official day of business, where they either gave a thumbs up or a thumbs down on multiple matters that were pending review by the United States Supreme Court. Now, there was a wide array of issues that were still sitting before the United States Supreme Court. We're going to focus on 2. The first is assault weapon bans. And as we know, we had multiple cases out of the state of Illinois, all pending review by the United States Supreme Court. The second issue that we need to focus on is nonviolent felons and cannabis users. So cases such as Range and the Daniels case, they were also sitting on the doorstep of the United States Supreme Court. But here's the thing, America, I got no good news on any of them as it relates to all of the Illinois assault weapon ban cases. All of these cases right here, the court has denied petition for certiorari. Okay, let me say that again. The court has denied the petition. And the reason, as many speculated, including here on this channel and other of my colleagues out here in the YouTuberverse, is that these cases had not reached the level of maturity. They were still in what's called an interlocutory phase, which is fancy lawyer words of saying the game's not completely over. You're trying to appeal in the 3rd quarter here. And that is not typically the posture in which a case will be accepted for review by SCOTUS. Now, as you can imagine, there was differing opinions by the justices as it related to whether or not this issue should be accepted for review. Now, Justice Alito would have actually granted certiorari at this point. The opinion denying certiorari was shockingly written by Justice Thomas. Now, there is a lot of very powerful language that the justice uses here in describing why this is an absolutely horrific ruling and why the 7th Circuit has a long way to getting this right. And there certainly is acceptance language in here that should this thing not resolve differently, that the United States Supreme Court will have to take this. But what does that mean to all the good folks in Illinois right now? Well, it means a whole mountain of beans to them, because they're going to be living under the purview of this unconstitutional law now for the foreseeable future. Justice Thomas was concerned that apparently the lower courts just do not have enough guidance from current case law to understand which arms are actually protected by the Second Amendment, which as we know, it's all arms which are in common use today. But as Justice Thomas wrote, but this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. And as you know, the Seventh Circuit created this whole new rule of law out of thin air, which is more appropriate for military use. Now, Justice Thomas also addresses this. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. And even on its own terms, the Seventh Circuit's application of its definition is nonsensical. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. Justice Thomas, I absolutely agree that it is completely nonsensical. It's almost impossible to imagine a scenario where that conclusion could have been reached. But then again, hey, congratulations to the Seventh Circuit. But apparently, no matter how profane, no matter how absurd, no matter how ridiculous this opinion is from the Seventh Circuit, well, it's just not quite enough to get reviewed by the United States Supreme Court. As Justice Thomas did write, but if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. But you see, Justice Thomas, that is exactly what the state of Illinois, and that is exactly what the Seventh Circuit has done. And if you honestly think that the guidance that this court is going to provide the Seventh Circuit is somehow or another going to change the outcome, well, then I question whether or not you guys have been reading the opinions of the Seventh Circuit. Now, the other big issue, America, as you recall, is nonviolent feloners, i.e. what we saw in the matter of Range versus Attorney General of the United States, and cannabis users, as we saw in the matter of United States v. Daniels. Both of those cases have been granted review. The rulings have been vacated by the Supreme Court, and they are now being remanded down to the lower courts to have rulings consistent with the findings in United States v. Rahimi. Now, if you will recall, United States v. Rahimi clearly said that if a person is deemed dangerous, they may be disarmed. But they left open the question as to those that are unlawful or irresponsible, which Range and Daniels would more appropriately fall into those categories. This is going to go down both to their respective lower courts along with the Rahimi decision for a do-over. What's likely to change? Nothing. You don't believe me? Well, just take a look at what happens when we GVR'd everything out of Bruin a couple years ago. Remember, there was 4 cases that got GVR'd on one day. How many of those cases actually changed their rulings post-Bruin? Oh, that'd be 0, exactly. So what this really is it's an opportunity for these cases to go back down, to ricochet at the lower courts, to get delayed by those that do not want to advance this cause, and ultimately those individuals who may have an old nonviolent felony or some other old criminal conviction precluding them from exercising their inalienable rights, they will continue to live in this situation for the foreseeable future. Now, there were several other cases also that were either denied certiorari today or GVR'd, several of the nonviolent felony challenges out of the 8th Circuit. So in the case of Vincent v. Garland, that case has now been GVR'd back down to the 10th Circuit. That was a challenge to nonviolent felonies in that circuit. The case of Antoniuk v. James, a case out of New York, also deals with all sorts of issues related to New York's Concealed Carry Improvement Act. That too was GVR'd today back down to the circuit court for findings consistent with United States v. Rahimi. Cunningham versus United States, again, another nonviolent felon issue, this one out of the 8th Circuit. That was GVR'd back down to the 8th Circuit today with instructions to make a ruling consistent with the holdings of United States v. Rahimi. Doss versus United States, another case out of the 8th Circuit dealing with nonviolent felonies. That case was also GVR'd consistent with the previous case we discussed. So for any of you who were hopeful that next year's Supreme Court term will finally be able to answer the assault weapon ban question, the high capacity magazine ban question, the nonviolent felony conviction question, the cannabis user question, yeah, I got bad news for you. None of that is going to happen. In fact, right now, it appears that there will be no major Second Amendment case on next year's Supreme Court docket. Now, there's another case I want you all to be aware of, because with all of these Illinois cases suddenly getting GVR'd, and they're going to go back down to the Seventh Circuit, and we know they're going to play games over there in the Seventh Circuit. We know it's going to get stalled out, and it will just go there to age like fine wine. All of what we've seen with both Miller and Duncan in the Ninth Circuit. For that reason, I want you all to pay attention to the case of State of Washington versus Gators Guns. This is a challenge to Washington State's high-capacity magazine ban, which is now scheduled to be before the Washington State Supreme Court later this summer and will likely be on this coming year's term for argument on the merits, which means by early 2025, you may have at least a high-capacity magazine ban case which has reached complete maturity and therefore would be ripe for acceptance by the United States Supreme Court. We're going to link that case up below. You guys might want to start geeking out on it. Listen, we're going to go ahead and link up everything that we use to make this video down below so that you can geek out on it for yourself. Maybe you got questions about this or something else related to what's left of our Second Amendment rights. If you guys do, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing here. Hey, if you do, go ahead and click on that link right there. Some of the best ideas we had weren't really our ideas to begin with. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.